First, I want to thank you for allowing us to come before the board once again. An opportunity here. Congratulations, Commissioner Aguiar, for your new position. And I'll let Michele start if she has any to say. Honorable Commissioners, we sit here before you today with two straightforward requests that could help resolve our ongoing situation and benefit our entire community. First, opportunity for remedy. The timeline of events is clear. In December 2021, this board issued a cease and desist order to the Tipi retreat and denied our land use change request. However, the board did not provide the legally required findings of fact or offer us the opportunity for remedy as required by the land use plan. After nearly 2 years of legal proceedings, Judge Simpson found 2 of the 3 remaining claims against us to be arbitrary and capricious. The final claim simply indicated that the county could have requested a Wyoming licensed engineer report on our private road. A straightforward matter that could have been easily addressed had we been given the opportunity for remedy. Therefore, we respectfully request the board, 1, grant us the opportunity for remedy that should have been provided in 2021. 2, schedule a rehearing of our land use plan change request during the February 4th, 2025 commission meeting to allow sufficient time for all required public notices. Our second request is let's move forward together. A notice of appeal to the Wyoming Supreme Court was filed on December 27th, 2024, but this is not the path we prefer. Despite our repeated attempts to mediate and find common ground, we've been unable to secure a meeting to discuss potential solutions. The current situation is costly for everyone involved. It consumes taxpayer dollars. It drains county resources. It prevents economic growth. And it divides our community. We propose a simple solution. Both parties agree to drop their claims. The board follows the established land use plan procedures. And we work together to begin healing our community. The path forward. Let me be clear. Pursuing this case to the Wyoming Supreme Court would likely establish important precedences protecting property rights and due process for all of Wyoming citizens. And the arbitrary denial of land use rights without proper findings or remedy opportunities affects not just us, but potentially every single property owner in our state. However, we sit here today offering this board an opportunity to demonstrate their leadership by supporting economic growth, protecting property rights through proper procedure, following established land use plan guidelines and procedures, managing taxpayer resources reasonably and responsibly, and healing our community through positive action. And the choices before us here today is significant. We can proceed to the Supreme Court where a ruling could strengthen property rights statewide, but at a considerable cost to our community. Or we can work together now, find a solution that respects both the law and our community's needs. We are prepared to pursue our legal rights to the fullest extent. We believe our community would be better served by working together to resolve this locally and setting an example of good governance for other counties across Wyoming. So in closing, we ask you to consider what kind of legacy you want to leave. A community divided by lengthy legal battles, or a community strengthened by fair process and mutual respect. The solution is within our reach, and we simply need to follow the established land use plan and work work together in good faith. Thank you for your time and consideration.
Okay. Well, you know, I agree with everything that you said. You know, the one part that our plan was found to be legal, and you know, to be clear, we didn't sue you, you sued us to start with. So
Do you understand why?
okay, I understand why you did that, but you sued us, and then, you know, in the finding us arbitrary on 2 of the 3 counts, that's on the absolute checklist, and all it takes is 1 to deny the request, and the judge upheld our order. So, and 2 is, you know, I think we have to make a decision. They awarded the county $40,000. So then that has to be the decision of this body that they want to forego the $40,000. That's what you're appealing, but you know, that money's out there, and it's basically been awarded to Hot Springs County, so we would have to decide that we didn't want the $40,000.
So actually, the Supreme Court would decide that.
Well, they would, but
I don't think you understand what the appeal is about.
The appeal's about the decision and whether our plan's legal again, so. This is my
Correct.
understanding,
And
so,
by moving
So
forward.
wait
so we're
a
gonna
minute,
argue.
you said that you understood why we sued. So why do you think we sued?
I assume you didn't like our decision.
Because you didn't allow us remedy, and the land use plan offers remedy. You didn't follow the land use plan.
You know, I'm not gonna speak to that here without, you know, I had no idea what you were coming to talk about. I mean, and I think if we, we'll take your decisions or your offerings. I don't think we should make a decision today. I mean, the attorney hasn't seen any of that. Land use planner back in the back hasn't seen any of that. So we're sitting here going, what are they gonna come talk about? So for us to make a motion and make a decision without, you know, we've been 4 years. 4 years of trying to get this resolved, and
So why
a lot
didn't you
of,
accept?
I'm talking, you can talk when I'm done. So it just goes on. I just don't think that we should make a decision. I'm, you know, that's the decision of this board to do that. I'm okay with that. But I think they ought to be informed of all the ramifications of that.
So you're okay with going to the Supreme Court and spending an additional
Hold on a minute.
50, 60,
So,
80, 100?
Just a moment.
I'm-
You said you weren't ready to make a decision yet. We didn't ask you to make a decision today. We asked to be reheard, to follow the land use
So we
plan,
have to go
to
back
have
through
remedy.
to the.
Hold on, I'm not done speaking.
Okay,
For February 4th, so that there would be time to do public notice and be reheard per the land use plan, which states that remedy should allow us to change what we need to change. And what the judge stated, the only thing you could have asked for was for certification of the road. That was the only absolute that you won on, and we had certification of the road from the previous county commissioners, but he said you could have asked for an engineer's
So-
certification, which we do have now.
all right.
So why would you
I think we need to have time to see what that is. Let's go through the process. And we'll let the planner get a hold of you and say that it's worth that. You know, as far as the other 40,000 and the previous decision. I mean, it has to be these, that we want to give up 40 grand. You know, the Supreme Court will decide it or not if they take the case.
The Supreme Court, if the Supreme Court rules in the favor of Tipi Retreat and Mike Michele Stevens, then it gives them the opportunity to pursue damages, which could be very extensive at the end of the day towards the county. So the risk that's there, yes, it's the one the Supreme Court would have to rule in that manner. I think as what they are presenting as the avenue of remedy is when you think about government forces, I'm reading a book now that talks a lot about property rights from our founding forefathers, and there's just when you have a government authority that basically dictates what you do and what you can do for your property, there needs to be an avenue of recourse, an avenue of rebuttal. Because if not, you're just a big mouth. You're gonna slam the mouth down the table and say you have to live by our choices. That's all there is to it. That's not the Constitution of the United States. You should have the right of rebuttal. You should have the right to be able to come back and say, I disagree with that decision because it affects my property. According to John Adams, our property is as sacred as the laws of God. And so there should be an avenue of rebuttal. I've even mentioned this to the state attorney general, says, where's the avenue of rebuttal in relationship to a county commission board that sits and then dictates and orchestrates the restrictions of somebody's property? If they don't have an avenue of rebuttal, what are they left to? And he simply said, go get an attorney. And so that was the avenue of rebuttal that is offered, unless you mutually join together to discuss those options and bring resolve. And so, as mentioned, what that does is just cost a lot of money, and the lawyers are real happy at the end. Because you did provide an avenue of rebuttal, an avenue to come back and to say, I think we can meet your disagreements. Let's see if we can't come to a mutual understanding. And so I understand. I as you read through Judge Simpson's remand letter, and talked about the opportunity to be able to come back and resolve these things without having to go through the court system. I believe is a much more thoughtful approach. So therefore, I would move that we make a motion that there be a public hearing held on the first official Board of County Commissioners meeting for the month of February, that day being February 4th, 2025, for the purpose of providing remedy for Tipi retreat, Mike and Michele Stevens. Evidence will be presented and resolution to be determined in that public setting, with notifications of the public hearing to be posted in the independent record.
I second.
Okay. Other discussion?
Discussion is that we will follow due process of filling out our absolute relative checklist. You've already gone before in regards to this matter. You've gone through the land use planning committee already. We approved that 2 years ago. I do not see that, at least according to my understanding, land use board, that again is required because you've already done that. And so I think we can move forward with this. I think we can bring resolve to it. I am not in favor of the county going forward to the Supreme Court. And I think that we should come to mutual agreement and move forward.
Okay. Other discussion?
You know, I'm much of a voice for everybody in the back. I have laryngitis. I think it's about time we come to a resolution on this issue. I'm glad to see something is going forward. I think the community wants it. I know I was running my campaign. Everybody said they wanted a resolution. One way or the other, resolution, just put it to rest. So I'm glad this is finally going to come to a point where we can all sit down together and agree on something, or maybe agree to disagree, but finally get a resolution.
Okay. Other discussion? Hearing none, all those in favor signify by saying aye.
Aye.
I
Opposed, nay. Motion passed.
I would also like to make another motion. And this is in regard, I move that any future outside legal expenses, that being other than our county attorney Joe Logan's office, in regards to Tipi retreat, be approved by Hot Springs County Board of Commissioners prior to services rendered.
Second. All those in favor signify by saying aye. Aye.
As a matter of note, we have spent, as of the 6th of this year, a total county expense of $167,670.24 to the Bud Fallon Law Firm.
Okay. All right. Mark, you're up next.